Good morning, ladies and gentlemen. Welcome to the Zoom session of the 10th Court of Appeals, beginning at 9 o'clock on April the 20th, 2021. This oral argument session is at this time being both recorded and provided live stream on YouTube. And so it is the public forum for the courtroom. In addition, there are at least one university, Sam Houston State, that is actively making this session part of their course curriculum in some of their courses. I know that Blinn is aware of today's oral arguments, and they may also be not participating in it, but doing the same thing with regard to coursework. And so be aware that that is, like I say, it is being live streamed as well as recorded. Before COVID-19, we had begun audio recording our sessions, and then at the end of the session, linking those audio recordings to our case management system so that you or anyone else, your clients, the public, other attorneys in your firm, hopefully not your insurance carrier, could refer to those videos at any time and make use of or the audios at any time. We now do that with the videos. So you have both audio and video linkage to the case file should you need it in the future. As with the arguments, if we were in court, I ask you to limit distractions. I am pleased to see that everybody does not have open windows behind them into an office space. That is very helpful to have that blocked out. I see Counsel Ruttinger has the blinds drawn, so there won't be a distraction behind him. So it seems like maybe y'all have done this before, and that is good, and we appreciate that. It's still kind of new to us. We don't have a whole lot of oral argument sessions to begin with, and so we're still getting used to the technology as well as trying to coordinate it all. You will see the timer in the, I think it will stay in the upper left-hand corner of your screen. Keep it on the gallery view. That will give you your countdown to how much time you have left. It will go to all zeros as it is now when your time has expired. I may extend your time. Feel free to wrap up. But if you get a question, obviously feel free to answer that. But we will be trying to keep it within the time restrictions. As you know, the clerk had provided to you a YouTube link. Your clients, other attorneys in the firm should be able to watch there, as are the students, as is the court staff. Normally we would have our court staff in the courtroom, but they are all on the YouTube channel. Are there any questions about the procedure that we will be using? Any of the participants? At this time, I would normally, I do anticipate that we'll go straight through the first two arguments. There are three on today's docket, and then we'll probably take a break, probably about 5 minutes before we hear the third argument. If there are any, and I haven't been provided any, so I assume there's not, is anybody going to be using handouts or exhibits for oral argument today? Okay, I see negative from all the attorneys. The judges don't get to answer that question, and so, but they do get to answer this question. To the judges or the clerk, is there anything that I have failed to mention in the opening here?
No, sir.
Needed, good, okay. I'm going to assume, let's see, Matt, I hate to do this to you at the last minute, but I'm going to, one of the complaints that we got when we did this before is that people watching the tapes afterwards were not able, oops, I, of course, changed the wrong justice. Give me just a minute. Here we go. One of the complaints was that they could not tell who the speakers were. And so, yes, John, I will rename you back to something that looks appropriate.
Please do that. I would appreciate
it. Twin brothers with different mothers. All right. How's that? Is that better, guys? All right. I will ask that if you are not speaking, that you mute your mic and turn off your camera. And then that way it avoids the distractions that will occur as people move and there's movement in the background, and it will help us if the camera is turned off as well. At this time, I'm going to call the docket. And I would like announcements of from the person that will be making the argument. Mack versus State.
Good morning, Your Honor. Stan Schwiger for appellant, and we are ready.
Thank you, counsel.
Good morning, Your Honor. Tara Avance for the state of Texas. And
okay, thank you, counsel. We will start with y'all's case first and do that in just a moment. The next case on the docket is Campbell versus State.
Jonna MacArthur for appellate, and I'm ready.
Thank you, Jonna. David, you're muted, but I can tell you're there. Did you give me a thumbs up? Are you good to go? All right. Third case on the docket today, after the two criminal cases, is Dupliced versus Nimbus.
Yes, Your Honor. Jay Ritter on behalf of the appellants, and we are ready.
Matthew Doss, attorney for appellee Nimbus Properties LLC. We're ready, Judge.
Okay, and like I say, we will probably take a brief break before that one starts, but not knowing exactly how long the first two will take, would ask you to stay handy. I will say for the litigants, your cases were chosen with some degree of interest on the issues, and for the students, it brackets the trial process and then the presentation of appeal, because in the first, in the two criminal cases, they both deal with the events. Primarily, there is one sufficiency of the evidence challenge, but they deal with the charge, which occurs at the end of the trial, and it's sort of the where the trial ends and is turned over to the jury. On the other end of the spectrum is the last case for the day, which is civil in nature, and it is about basically getting in the courthouse door and getting the case in front of a trier of fact. So those are the cases that will be presented today. And at this time, the court calls Mack versus State.
Good morning, Your Honor. May it please the court, members, fellow members of the bar, fellow members of the state, and also folks that may be watching on YouTube. Good morning. My name is Stan Schwiger. I am the attorney for Mr. Mack, and I represent Mr. Mack on appeal. As Justice Gray pointed out, the questions before this court deal with the application of the instructions of necessity and self-defense to Mr. Mack's jury charge, And those charges were harassment and evading arrest. And as Justice Gray just mentioned, in addition, Mr. Mack also challenged the legal sufficiency of the evading arrest with a prior conviction. And also, because we are challenging the legal sufficiency, because that provides the greatest relief possible, I'm going to begin with that one. The elements of evading arrest constitute 6 elements, but the most important one to this one is the attempted arrest. Was the attempted arrest lawful? And the case of Rodriguez versus State, found at 578 Southwest 2nd 419, a 1979 Court of Criminal Appeals case, deals specifically with this matter. It is instructive in the sense that the initial detention in that case did not amount to reasonable suspicion or probable cause, and therefore the court found that the subsequent arrest arising out of that unlawful detention would likewise be unlawful, and therefore found the evidence insufficient to prove the lawful arrest element of the statute. In that matter, the officer saw an individual walking down the sidewalk, looked over his shoulder. The officer found that suspicious and therefore came to try to detain him. At that point, the defendant in that case fled, and again, the court found that that element was not met as a lawful arrest. The state, however, cites Day versus State at 614 Southwest 3rd 121, 2020 Texas Court of Criminal Appeals case, supporting the proposition that the arrest was lawful in this matter. But I will ask this court to examine that case closely and show how it is an opposite to that conclusion. Day is correctly cited for the proposition that the exclusionary rule has no application to the lawfully arrested element of evading arrest. However, that case does not support the fact that the attempted arrest or detention of Mr. Mack was somehow lawful. Recalling the sequence of events in this case, we had an initial entry into the home following what was reported as a pedestrian car accident. The police noted blood on the outside of Mr. Mack's home, entered under the guise of community caretaking or exigent circumstances. They confronted Mr. Mack eventually at taser point in his bedroom where Mr. Mack told them to leave. They did. After that point, they walk out, and during this time, there is a report that Mr. Mack had actually assaulted someone during that incident. But if the state is heard
to be clear, you're talking about the incident with the automobile, not the incident in his bedroom.
That's correct. The assault occurred supposedly when Mr. Mack, I believe they termed it as full backing the automobile and running headlong into it. And apparently there was an assault that occurred after that. But if the state is to argue that this somehow justifies re-entry into the home and attempted arrest of Mr. Mack, it is contrary to the laws of the state of Texas. The only way that they could have entered without a warrant at this point would have been exigent circumstances. None existed. And also under the Code of Criminal Procedure, under Article 14.01, a warrantless arrest must be justified with offense that occurs within their view. In the case of State versus Steelman, found at 93 Southwest 2nd 102, a Court of Criminal Appeals case in 2002, an offense that occurs within one's view means that an officer has awareness of its occurrence from any of his 5 senses. The only indication the record has is that this report came quickly after the initial report of the pedestrian car accident, but does not justify warrantless arrest or warrantless entry into the home. No exigent circumstances were presented.
Counsel, if he had stayed in the house at the point of time of his the second reentry. Would the situation be different than where he jumped out the window and is then in the yard and they are trying to detain him, and at that point they are aware that he is a person of interest in connection with the alleged assault that had already occurred?
I believe the flight was generated from the police actions, and the police cannot generate an act to basically somehow follow an unlawful act. And what I'm attempting to say is that the police re-entering the home was illegal. His actions were justifiable, and therefore, because they still had no warrant to arrest him or detain him at that point. They may have been able, if they had seen him on the street later, to basically talk to him and do a consensual encounter, but there was no reasonable suspicion, no probable cause, no warrant to stop and arrest him at that point. And that's the actions that actually culminated in his arrest.
But the state argues there were 3 attempted detentions, as I understand their brief. The first one being the one in the bedroom. I don't think they seriously controvert your argument that the reentry was without justification, but then his flight from it, that may have been okay if that was the first evading, if you will. But then there was the second and the third at the point at which he was first ineffectively tased and then second effectively tased. As I understand your argument, you view all that as one flight and do not break it up into separate periods of time in which Mr. Mack should have stopped fleeing.
Nor can just the fact that he was in the home or on his curtilage or outside out on his yard does not change the fact of the legality of the arrest. The police are no more entitled to enter a curtilage or outside the area of the home than they are actually into the home itself to conduct an arrest. And that's what they were there to do. They were not there to basically detain him, nor could they enter the home to do that. The fact that they pursued him onto his yard does not change the characterization of the legality of the detention. The legality of the detention is controlled by a warrantless arrest. Nothing occurred within their presence to warrant the arrest.
But they had obtained additional information before they re-entered. They did not know that he was a suspect. So when he was in the yard, after he had jumped out the window, at that point, they did know that he was the suspect in an assault. Does that not change their authority to conduct a detention at that point?
I do not believe that there were exigent circumstances to enter the yard of the appellant at that time. They would have had to have exigent circumstances. They were sitting outside ruminating on what to do next. If they obtain this information, the preference of the law is always to obtain a warrant first. And they could have gone and obtained a warrant. They had no justification to enter the land, enter the house whatsoever under this state's laws and under the Constitution. It does not change the circumspect and does not change the application of day in this matter. Because recall in day, the relation back to the exclusionary theory, as the court put it, was the issuance of a live valid warrant. And they related that back, or in property terms, the springing executory interest. It came up at that point, and therefore it related back to the initial stop, and it was valid at that point. The fact that they did not know about that was inconsequential. It was merely the fact that the issuance was rendered lawful by the issuance of the warrant. We believe that day controls Absolutely. But again, day controls because there was no valid reason to enter or arrest Mr. Mack at that time. And as such, therefore, the evading arrest should be found to be legally insufficient and set aside and remanded for judgment of acquittal. Let's concern the necessity and self-defense instructions and the common element that the state argues between these two justifications that both require confession and avoidance.
Counsel, before you get to that point, if you would, the state raises a question of whether self-defense is even applicable in a harassment of a public servant charge, allegation. And if you would address that question before we get to the confession and avoidance issue.
Absolutely. If we're talking about in the manner of self-defense, that is limited as necessity is not, but self-defense is limited where the actor is charged with an offense involving the use of force against another. The state responded, as the court pointed out, should self-defense apply in this manner to harassment of a public servant? And the question is not specifically reading the statute, but again, what actions justified Mr. Mack's actions to begin with, and reading the self-defense statute to begin with. The state argued, well, spitting is not force. Well, there's not a lot of law on this, to be shocked. I know you're shocked, but there is a District Court of Columbia Court of Appeals opinion that cites two Kansas cases, both unpublished, which stand for appellant's proposition. And I think it's right. And what they say is it's difficult not to imagine a scenario in which spitting could conceivably constitute a use of force in self-defense, whereas in this instance, for example, where a person has been placed in a chokehold, spits at the aggressor to get him loosen his grip. That is Parker versus United States, 155 Atlantic 3rd, 835. And I'll supply all these sites to the court in the letter brief. So I believe absolutely the use of force can apply in that manner. So spitting is force. So as to the applicability of self-defense to the harassment charge, the penal code specifically says the use of force is justified against a peace officer when there is excessive force used against him. Again, I return to my argument that the initial arrest was simply illegal. The initial detention was simply illegal. And an inference could support the finding that the force used was excessive and that Mr. Mack's spitting was his only defense against the unlawful use of force against him in that matter. The state then argued, well, tasers aren't force, and just basically citing that. But again, this is a matter to where the use of force against another is only justified under the penal code in terms of arrest. And when the arrest is unlawful, he has the right to defend himself in the only manner possible he found himself at that time. Concerning the argument against the EMT, as I pointed out in the brief, this unlawful detention continued to where he was hauled to the hospital, and the EMT at that point was a continuing participant in the illegal arrest and detention of appellant. Since his right of self-defense continues until the necessity to use such ends, he had the right to use the only mechanism he found himself to be in at that time, after he was tasered, after he was illegally arrested, after he was held to the hospital, and after he was cuffed to a gurney.
Yeah, counsel, I thought the law was pretty clear that the person being arrested, if there was not an unreasonable, excessive force being applied, had no right to be combative and fight the arresting officers. And certainly the state so characterizes this, and they were fearful that he was going to kick out the windows in the patrol car, and so they were trying to put leg braces on him. They were, in the first instance, when he spit on Officer Owens, and then they were trying to render medical assistance to him when he spit on the EMT. So even if the arrest is unlawful, if they are not exerting excessive force, then it was my understanding that the person being arrested does not get to be combative.
And I agree with that stance, Your Honor. But the question is the lawfulness of the detention. And the statute, as I understand it, states that anybody that is lawfully arrested cannot resist arrest. When they are using greater force than necessary to conduct an unlawful arrest, then I have the right, as I understand it, to basically continue to use self-defense against that unlawful force. And I would argue that tasers and being
But every
submitted,
officer has a taser and a handgun and a billy club and a flashlight on them, but they're not always using it, and they may need it to maintain the status quo.
and I agree with that. But in the sense that basically when we start from the position of an unlawful arrest, I think that's where I think this case is distinguishable, because there is a situation that the initial detention was unlawful, continued to be unlawful until the time of the hospital. And, until that time, I believe that he had the right to use self-defense to continue to use, actually charged by some complaint or something, to use those defensive mechanisms to defend himself at that time. I just think I think it is a continuing unlawful state that he is in to have him utilize self-defense.
Okay, your time is expiring, but go ahead and address the issue on the instruction.
Thank you, Your Honor. This matter deals with confession and avoidance, and I think I can briefly talk about it in 2 minutes. There are two relevant cases to my understanding, one from 1954 and one last year, an unpublished case that this court cited called Ebicon versus State, a Court of Criminal Appeals unpublished opinion at 2020 TexApp, unpublished Lexus 359. And there's a diversity of opinions on what confession and avoidance means. But I think returning to the fountainhead of this matter, if we look back to the fountainhead, the 1954 case of Kimbrough versus State at 249 Southwest 2nd 919, that's where the Court of Criminal Appeals initially talked about this particular doctrine of confession and avoidance. In that matter, the defendant claimed to have drank a pint of whiskey after being stopped for driving while intoxicated, and said, "I wasn't driving drunk. I was publicly intoxicated by the consumption of the pint of whiskey after my arrest." In the court then said that such testimony constituted a denial of the truth of the charge, and if that be true, then it is not an affirmative defense. In Ebicon, the majority looked at the following facts. There was a dispute between a girlfriend and Mr. Ebicon. Apparently, she was trying to force her way into the home of Mr. Ebicon, or so he claimed. The girlfriend claimed she got punched in the mouth and it broke her lip. Mr. Ebicon said, "No, that's not the way it happened. It happened when I shoved a door into her, and it must have broken her lip at that time." At that point, the majority found that basically there was no confession and avoidance at that point. It was not necessary for him to admit the specific manner and means as charged in the indictment, but basically gave an excuse that that showed that he was arguing self-defense. In Justice Urey, in his dissent, I think this is probably the most accurate law that we can find on it, but I think that what he says is accurate. He says that anything that is not a denial suffices for confession. We don't need to have a defendant testify, well, this is how it happened. That's just basically not required under the confession prong of confession and avoidance. He states that basically as long as somebody shows that he committed the elements of the offense, even if he denied it, but he was justified under Chapter 9 that he is entitled to either a necessity and or self-defense claim as it may be. And I think that the concurring judges and Justice Urey are correct in the sense that we have conflated this far beyond the requirements of criminal law as we commonly understand confessions to basically go in and give it up. I think that that is a label that has gone far beyond its usefulness, and this court should so find.
What is the evidence that you can point to that's in the record where that you would characterize as a confession? Or at least meeting the predicate to get the self-defense instruction?
I think that Justice Urey is correct. It's basically a showing that the state proved that somehow that there is sufficient proof that he committed the offense, and that the self-defense claims arise, as I previously told the court, as previously explained to the court. That's all that's necessary. It doesn't need to be strong. It doesn't need to be weak. It's just basically some evidence arises at that point, and I think that's all that's necessary. And I think Justice Urey's stance on that is correct.
So even as in this case, if the defense, even though that Mr. Mack didn't testify, the defense's, I guess, defense through cross-examination of the witnesses was that it was, the spitting was maybe a natural reaction, or maybe he just needed to spit. And so, or maybe it was an involuntary reaction to the situation. You think even in that situation where he's affirmatively trying to negate an intentional spitting on the officer, that would still trigger a requirement to include the self-defense instruction?
I don't believe that if true that a outright quote unquote denial denies a confession, as I don't believe anybody found specifically in this matter, because I don't believe that question was before the court in either Ebicon or, but to answer your question directly, I think that Justice Urey's formulation of the law is correct. No matter what, if there is evidence that gives rise to this and the state points out that there was an offense committed, I think that's sufficient. I do not believe that the questions or concerning the, I guess the court would be pointing to questions asked by the defense counsel, and those specifically are not evidence. And I don't believe any evidence was raised as to specifically show that he was doing those actions in anything other than a defensive manner. I see my time is up.
Any other questions from the judges? All right, thank you, counsel. You'll have 5 minutes for rebuttal, and counsel, you may proceed when ready.
Thank you, Your Honor. May it please the court, Mr. Schwieger? If I may pick up where Mr. Schwieger left off on the confession and avoidance doctrine, I think the issue in this case of what his issues that he's presented boils down to is he's asking the court to render an opinion that not flatly denying the conduct is sufficient to entitle Mr. Mack to a self-defense instruction. He's asking you to pose a double negative, essentially. And self-defense is an issue that requires the defendant to produce some evidence. He has the burden of production on self-defense. And so there's several cases actually pending in the Court of Criminal Appeals, petitions for discretionary review, that are asking the court to decide, what does a flat denial look like? This language that was used in Epicom. I think here there was not sufficient evidence to amount to a confession by Mr. Mack. And so if we're looking just to the merits, assuming that self-defense does apply to harassment of a public servant, I don't think he wins on the merits for that reason. Mr. Mack presented a defensive strategy throughout the trial that this was an accidental spitting, both on Officer Owens and on Captain Brown. And while, yes, the defense attorney's questions are not evidence and his closing argument is not evidence, I think that that gives the court insight as to what defense Mr. Mack was trying to present at trial. And a self-defense instruction doesn't comport with an accidental spitting defense. In closing argument, his attorney said, we're going to argue that he did not intend to spit on anyone. And so it doesn't make sense that Mack could have believed that spitting was immediately necessary to defend himself if this was an involuntary or accidental act. And if I may go back to the threshold argument that I presented on self-defense as to whether that even applies to harassment of a public servant, I think there is room for argument that spitting could constitute force. I cited to Bogut v. State, which talks about how self-defense is normally applied in the context of an assault or a murder case. But in Bogut v. State, they talked about how in a criminal mischief case is if the defendant is directing force at another individual. In that case, I believe he took a flashlight and broke the driver's side window of the victim, that could constitute force. So I think the answer is maybe spitting could constitute force, but even so, when you look at the elements of self-defense compared to the elements of harassment of a public servant, they're not compatible. With the justification defense, the defendant is required to produce some evidence that, yes, this crime occurred, but here's my justification for why I committed this offense. And if you look at the element of lawfully discharging an official duty under harassment of a public servant, it doesn't make sense for the trial court to allow the jury to make a decision finding that, yes, harassment occurred, yes, the officer was lawfully discharging an official duty, but then to come back and say, but it was justified because unlawful force was used by the public servant, which gave the defendant right to spit on him. It's just not rational to allow the jury to make that finding. And specifically in the context of looking to count 2, where it was against Officer Owens, a peace officer, where there's even more of a limited right to self-defense. It's not compatible to find that he was lawfully discharging this official duty, but then also used excessive force against the defendant. And on that note, the state argues that there's no evidence of excessive force in this case. Yes, there was a use of tasers, but just like Chief Justice Gray pointed out, officers routinely carry tasers and that those are used when the situation arises. And in this case, the defendant was evading from the police, continuing to evade even after being tased the first time. He tried to jump the fence to get out of his backyard. He tried to put his hands up in a fighting position, is what Officer Owens testified to. He was showing signs of aggressiveness, so that was why they found the need to use the tasers. There was a case that I cited to in my brief, Torres v. State, where it was a very similar incident where the defendant was tased twice, once unsuccessfully, the second time successfully. The defendant requested a self-defense instruction and the court said he was not entitled to that instruction because excessive force was not used.
Was in the case that you just cited, was the defendant at his own home or in his yard at that time?
Your Honor, I'd have to go back and check the facts specifically, but I don't believe he was in his own home.
And what I'm obviously trying to link into is the whole evading arrest and the lawfulness of that. Once he exited the window, did it matter? And so I need you to address that before you're done today.
Yes, Your Honor. And turning to that issue, I think it's important to look at what happened before the officers arrived on scene. And Kimberly DiCarlo pulled up to the house. She was in her car. She was picking up the defendant's brother. He comes outside for whatever reason, chooses to approach her car, assault her. She reports to the officer that she had a bite mark on her arm. And he tackles her car, breaks the windshield with his head, and then goes back into his house. Ms. DiCarlo goes straight to the Mejia Police Department to make this report. Simultaneously, a neighbor across the street is calling to report a pedestrian vehicle incident. Different officers are responding to these two different places simultaneously. The first time the officers enter the house to check on the well-being of Mr. Mack, they did not know Ms. DiCarlo had made that report. However, when they exit the house, they do learn more information from Detective Rodney Irvin, who was taking the report of the assault at the Mejia Police Department, knowing that she has scratches, she has a bite mark. They saw the blood on the house around the doorway, and they saw Mr. Mack bloody. They go back into the house and they say, Eric Mack, we need to talk to you. They're trying to detain him. And then he jumps out the window. The state is not arguing that that second entry into the house was necessarily lawful, but whenever he chose to jump out the window and evade that detention, which we do argue they did have at a minimum reasonable suspicion to detain him based on that information that Kimberly DiCarlo reported of an assault and potentially a criminal mischief based on the shattered windshield. Once he was outside of his house and continuing to run from the officers, not only once after he was tased the first time, but twice when he was tased the second time successfully, then they had a lawful detention. And that's what meets that element of the evading arrest offense and makes that evidence legally sufficient.
So you don't think that the fact that he was still, as opposing counsel argued, he was still in the curtilage of his home makes, makes a difference?
Well, Your Honor, I don't know that the testimony at trial necessarily defined exactly where the defendant was in his backyard. There's talk about him possibly being in the backyard near a fence, trying to jump over the fence at one point, and then coming around and being underneath the carport. So I think it would be hard to determine exactly where he crossed over from curtilage into an area, just the front yard maybe of his home if he is near the carport area.
Counsel, the issue that the officers entered the house the second time, which you concede was probably unjustified, which set in effect the chain of events that led to the arrest for fleeing, that doesn't trouble you?
Well, Your Honor, because of Day v. State, it does not. And I know we've talked about this a little bit with Mr. Schwieger, but if I may go back to that case, the court said that whenever we're looking at the evading arrest charge, that statute is directed at the conduct of the defendant, not the conduct of the officer. And so we're to look at the character of the detention at the time the defendant flees. And I don't think that necessarily means the first time he flees. I think the officers were lucky in Day that they were able to catch him the first time a few blocks away. Here, they were not able to. And so he continued to flee and flee and flee. And so I think if you examine the character of the detention at the time the defendant continued to flee outside of the house, once he had already been tased, been told to stop, get on the ground, I think that makes the re-entry into the house not applicable. Essentially, the defendant committed subsequent independent criminal acts separate and apart from the officer's re-entry that make that re-entry not able to taint their later actions. And that's kind of what Day talks about, how it's evading arrest evidence doesn't exist at the time for example, in this case, when the officers entered that house, that evidence did not exist. And so the fruit of the poisonous tree doctrine wouldn't apply because they're not attempting to suppress any evidence that previously existed before the officers committed an unlawful act. So
Let me ask you one question here. I know you say the evidence isn't clear whether the defendant was in the curtilage or not. If he was, does that make a difference?
I think that might affect amendment issues. It could be factored in, but I still think that if you look at, for example, the resisting arrest statute, a defendant doesn't have a right to resist an unlawful arrest. So if you make a rule that a defendant has a right to evade an unlawful arrest, where would that end? So if the defendant thinks the arrest is unlawful, does he have a right to continue evading? And where does that line draw in the sand where the defendant needs to submit to the lawful authority and then take up this issue at a later time? And so to answer your question more directly, I think it could be factored in, but here where it's just simply not clear, based on the testimony of all the witnesses at trial, I don't think that the curtilage would be a factor to determine whether or not this element was met to the evading arrest charge. I think that the court should not ask how Matt got into the yard if we're following the day rationale, but rather to look at when Officer Owens told him to stop, did he have a statutory reason to disregard that lawful authority? And just like I said before, with the resisting arrest law, you're not allowed to resist simply because it was unlawful. And I think that logic should apply here as well.
Is that because of the elements of unlawful arrest or of resisting arrest, or is it a common law constraint on resisting arrest that you cannot resist even an unlawful arrest?
I believe it's a common law, but I can look into that further and supplement a brief later this week, but I believe it's more of a common law and kind of from a policy perspective that we don't want defendants fighting back with officers because their subjective belief that the arrest is unlawful, that it's more important to submit to that authority before things get out of hand and then to come back and litigate that in the courts.
Okay. Yeah, that's going to be we're not looking for a full-blown brief on it, but if you find something that addresses whether or not that is an application construction based upon the elements of the offense of resisting arrest versus the a common law, in effect, protection of the officer that's overlaying that resisting arrest statute, that would be potentially helpful to our analysis.
Okay, yes, Your Honor, I will do that. If I may go back to the jury charge complaints, to touch further on the doctrine of confession and avoidance, if this court does find that self-defense and necessity do apply to harassment of a public servant, the jury would be asked to, in this case, because there was no testimony from the defendant and no admission from the defendant presented in evidence, that they would be required to infer his subjective belief as to whether the self-defense was immediately necessary from the circumstantial evidence of the state's case in chief. And the state would argue that that invites some baseless guessing from the jurors to be required to essentially pluck different facts from the state's case in chief to determine what was the defendant's state of mind, since they did not have the opportunity to hear from him. Do they know if the defendant was acting because he was scared, or was he acting because he was frustrated that he got caught for the crime that he committed? And I think this ties back to Mr. Schwieger's issue that he raised and that was presented in Ebicom, is is not flatly denying the conduct sufficient to entitle a defendant to a self-defense instruction. And the state argues that that's not sufficient, that there needs to be some more. And yes, while a defendant is entitled to a self-defense instruction, even if the evidence is weak or contradicted, I think that there's a difference between presenting weak evidence and presenting no evidence. And I think in this case, if you reach the merits of that argument as to self-defense or as to the necessity instructions, I think that you'll find that there is no evidence to amount to any sort of confession or admission or evidence to support those jury instructions. I think a defendant or a jury can infer potentially that a defendant had the mental state to commit an offense. But I think asking them to infer that not only did he commit the offense, but that he had this justification, this justified mental state to commit the offense is asking for speculation from the jurors. And as I touched on before, the strategy in this case from the defense was to negate the mental state. And the courts have been clear that when a defendant attempts to specifically negate elements of the offense, that he's not entitled to then come back and say that he was justified for committing that offense. And those justification instructions, as in this case that he's asking for, the self-defense and the necessity. I think Mr. Schwieger raises a question of, is every defendant who does not flatly deny the conduct entitled to a self-defense instruction? Should we just give all defendants self-defense? And I think that it's important to allow the trial court judge to have discretion, who's there viewing the evidence firsthand, to make that decision on whether there has just been weak evidence raised or no evidence raised. And I think in this case, the trial court judge was correct in finding that the evidence did not present entitlement to a self-defense instruction or a necessity instruction. And specifically, Your Honor, if I may touch on the application of necessity to the evading arrest charge. Mr. Schwieger has adamantly argued that the arrest was unlawful or that the detention was unlawful. And in doing so, that argument negates an element of the evading arrest charge, because within the evading arrest charge is the requirement that the officer was attempting to lawfully arrest or detain the defendant. So by attempting to argue that it was unlawful and negate an element of evading arrest, I don't think that that would amount to a sufficient confession to evading arrest to thereby entitle him to the justification of necessity. There was a case by the Amarillo Court of Appeals, an unpublished opinion, Cancino v. State, that examined this precise issue of whether necessity applied to a defendant who was charged with evading arrest. And the defendant in that case also contended that the arrest was unlawful, and the court found that he was not entitled to a necessity instruction because he argued that it was unlawful. Essentially here, Mack is trying to have his cake and eat it too, to put it in layman's term. He's trying to say, well, yes, the arrest was unlawful, so that conviction is insufficient, but then also he should get a necessity instruction saying that the conduct he evaded, an officer's attempt to lawfully arrest and detain him because he was, it was immediately necessary to avoid imminent harm. And I think you could look to the facts of this case too. What was the imminent harm that Mr. Mack was trying to avoid? If it was the officers coming into his house and trying to get him when he jumped outside the window, was that not avoiding that imminent harm? Did he need to continue running not once, but twice from those officers? And I see that my time is running out, so I will wrap up briefly, but the state obviously asked the court to affirm the trial court convictions on all three counts. The state contends that there was no error in the jury charge, that the trial court correctly denied the defensive instructions that were requested, and that also as to the evading arrest charge, that the evidence was legally sufficient to support that, and that if this court looks to Davie State, it does provide guidance, and that the reentry into the house should not taint the officer's subsequent actions in arresting and detaining the defendant. Thank you.
Thank you, counsel. Any questions, judges?
No, thanks.
Thank you, counsel. At this time, we'll hear the rebuttal from Stan Schweiger.
Thank you, Your Honor. I would first like to commend the state of Texas for their excellent briefing and arguments in this matter. We just happen to disagree on the facts and the law. I want to return to the evading arrest and the legal sufficiency of that. The state seems to argue that the common knowledge doctrine that the police learned separately that therefore justified the entrance back into the home, and that somehow they were justified in re-entering the home or the curtilage of the location. First of all, the record does contain a reference to fencing, and I believe that the Supreme Court has stated specifically on several occasions that fencing areas is evidence of a curtilage, because I believed he was basically tackled and detained at the time to where he was trying to jump the fence. So they're on the curtilage. The evidence is in that record. The evidence is also in the record that the second entry into the home was not justified by warrant, not justified under Texas law, and his detention merely because he fled an illegal arrest does not mean that he evaded arrest, because that's an element of the offense. The attempted arrest must be lawful, and there is no justification under the statutes, the Constitution, or the laws of the state of Texas that justify his arrest at that time. And so therefore that charge must fall.
Counsel, I know this is going to be kind of seem like from left field, but you've got a suspect in a location, a known location, and everything about that knowledge was appropriately obtained and communicated. Time is a factor in everything we do. Why is it inappropriate for the officer in this situation to make the contact? Because we're not talking about an expanse of time, and we're talking about a highly agitated defendant that is in a place where weapons were seen by the officers on the first entry. Why is it inappropriate for them to immediately endeavor to detain him based upon the additional information that they received that made him a suspect in the assault charge?
Because it's a entry into a home, entry onto the curtilage that was not justified by a warrant. They had time to get a warrant. They were standing outside. Nothing was happening during that time before they plotted amongst themselves to make the second entry. At that time, they justified their actions by learning this new information that was not provided to a justice of the peace or other judicial officer. No warrant was obtained. The Court of Criminal Appeals in Steelman is clear that basically even having that type of suspicion, in Steelman the odor of marijuana was present. The Court of Criminal Appeals said you cannot go inside the house, you have to go get a warrant.
So basically your position is they had to cordon off the location and wait until they got a warrant to enter his home or his curtilage.
Well, they could have, and I think the law provides for a consensual encounter. Go up and knock on the door again. See if he wants to come to the door and talk.
I think he'd already made it clear that he wanted them to leave.
And I agree. And so therefore, I think that's the only lawful manner that they could have approached him at that time. Certainly the Court of Criminal Appeals, the Supreme Court have all been very clear, without exigent circumstances, which there were none, because he was inside the home. It is the preference of the courts and the preference of case law throughout this land that you have to get a warrant to enter that home. And they did not. They were on the curtilage when the chase began. There was no lawful arrest. The evading arrest with detention must fall. In very short time, I urge this court to look at the opinion in Ebicon and look at Justice Uri's dissent, in that it is the only language that we have that clearly defines what constitutes confession and avoidance.
Just so you know, I'm going to report you to the defense bar for citing Justice Uri as being authority for the position you want to argue.
I am well aware. As a side note, Your Honor, he once told me during oral arguments at the Court of Criminal Appeals, when the line of cases was 125 years old, and he said, "Counselor, you understand we can change the law, right?" "Yes, sir, I understand that." And they did. So
Right.
I understand what you're saying there, but I think his point is directly applicable to the statutory. It's rooted in the statutory authority of self-defense and confession. And I believe that it presents an accurate statement of this defense, and I will concede my time to the court. I appreciate the opportunity to present arguments today.
Thank you, counsel. This case is submitted and y'all are excused. And unless I get a nod from one of the judges that they need to take a break, we will proceed to the second case.
Thank you both.
Thank you.
counsel. Okay, judges, are y'all ready?
Yes, sir.
Yes, sir.
All right. Counsel, you may proceed when ready.
May it please the court. Thank you, Your Honor. David, Vernon, and all those listening. This is basically a one issue case. I know the state presented it as two issues. I actually presented it as one issue with two parts. I'm going to address them separately. This case involves a murder or a death, a homicide. And many of the facts were not disputed in this case. And so the issue that we're looking at now, as Chief Justice Gray said before arguments, is a error in the charge. Specifically, in the way that intentional was defined. Generally, the term intentional is defined broadly as either a result of conduct or intending the actual result. So intending the conduct or intending the result. However, it has been well established that in a murder case that you must show that the result was intended. And in fact, the San Antonio Court of Appeals, citing the Criminal Court of Appeals, said that murder is an offense which requires that the culpable mental state accompany the result of the conduct rather than the nature of the conduct. A charge which defines intentionally or knowingly as they relate to the nature of the conduct as well as the result of the conduct is error. Now, the way that the court defined intentional reads this in the charge, reads this way. And it's on page 2 of the charge of the court, right at the top. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when his is conscious, objective, or desire to engage in the conduct or cause the result. This is exactly what the Supreme Court was talking about, and it is indeed error. But that's not how the end of our examination. We do have to show harm, and I think that's where this case is going to turn. It's whether or not harm. Now, the Supreme Court tells us.
I need to interrupt you there first before you get to the harm, and this may have been where you were going. But I don't know that I've seen you in oral argument before, and so I'm going to just make it clear that we have discussed this case among us, and there is a issue that the CCA has sort of recently resurrected as to whether or not you have a burden to show harm or whether or not we have a duty to examine it and determine if there is harm. Does that affect this analysis from your perspective?
I don't think so, Your Honor. This is more of a common sense harm, where we look at what the jury would have done following the instructions of the court and going along with this definition of intentional. I don't think it makes any difference one way or the other on that issue.
Okay.
Now, the Texas Supreme Court has told us how to determine harm. And in this case, it's when there is an objection made at trial court. And there was a timely objection made at trial court to the charge, and that objection was overruled. And the Supreme Court the Texas Supreme Court in Almanza v. State, and I have the citations in the brief, stated that if the error in the charge was the subject of a timely objection in the trial court, then reversal is required if the error is calculated to injure the rights of the defendant, which means no more than there must be some harm to the accused from the error. In other words, an error which has been properly preserved by objection will call for reversal as long as the error is not harmless. And that's at page 171 of that opinion. And we already went forward with how the state defined intentional. It should be noted that they actually define knowingly correctly without mentioning the result of, the nature of the conduct. They only mention the result when they define knowingly, but they define intentionally as either or. And one of the other things I wanted to point out, and because I did this when I first started looking at this case, I looked at it as an attorney would have looked at it. I looked at that charge, and knowing all the facts of the case, because I'd read many, many pages of transcripts, and I knew probably more than the jury did, I looked at it and I started where I thought the case should end up. But that's not how a jury does it. A jury follows the court's instructions. And we have to assume that they have followed the court's instructions if there's no evidence of jury misconduct, which there is not in this case. And juries aren't lawyers. They're told by the judge what to do. They have in this case, it was, how long was that jury charge? 13-page jury charge to follow. And I believe that they did follow it. So right now, I just want to put ourselves in the place of the jury. I'm not trying to substitute our reasoning for that of the jury. I just want to demonstrate what went on in that jury room, what had to have gone on in that jury room. The jurors went back to deliberate. They retired to the jury room, they selected a foreman, they read the charge. That's what they were instructed to do. And one of the things they were instructed to do, and I can't emphasize this enough, is that they were instructed to look at the first item on the verdict, which begins on page 9 of the charge, And that says, the first item says, we, the jury, find defendant Philip Andrew Campbell guilty of the offense of murder as alleged in the indictment. Okay, so they've got to decide whether he's found guilty of murder. If they find not guilty, then they go down to the next, which is addresses manslaughter. If they find that he's not guilty of manslaughter, then they go to the next. However, if they do find he's guilty of murder, they stop. Their analysis is over. Their job is done for this part of the trial, for the guilt innocence phase of the trial. So let's take a look at what they saw when they looked at that first choice. How do we find somebody guilty of the offense of murder? Well, the jury charge tells us a little bit about that. Under number 6 on page 3 of the jury charge, it says, and I won't read the whole thing, it's quite lengthy. I'll only read the pertinent parts, but it says, now bearing in mind the foregoing instruction, if you believe from the evidence beyond a reasonable doubt that the defendant, Philip Andrew Campbell, did then and there intentionally or knowingly cause the death of the individual, namely Alexandra Wright. So what's the first thing that they're asked to do? They're asked to determine whether the defendant intentionally caused the death of the decedent. So how do you do that? Well, you know what? I'm a juror, and I remember that the court defined intentional for me. So I go back to that definition of intentional at the top of page 2. And I'm saying, well, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. The evidence at trial was undisputed. He desired to engage in the conduct. The conduct was autoerotic asphyxiation. He had done it before with another partner, at least one. And there was no dispute that he did desire to engage in that conduct.
Counsel, let me interrupt. There was evidence, was there not, that he desired to engage in necrophilia?
Yes, there was some.
Sexual intercourse with a dead.
I don't know if that came up until punishment, but I don't think it has an issue. It's not an issue in this analysis because they didn't have to find that he had intent to cause the result. Their analysis ended when they looked and said, oh, well, there's undisputed evidence, plenty of it, that he desired to engage in the conduct. And the analysis can end there because of that or. All they had to find was either he wanted to engage in the conduct or he intended the result. And the easiest one to find is that he engaged in the conduct because that was entirely undisputed.
But are we not guessing at that, right? Are you not guessing?
I don't believe so, Your Honor, because I'm looking at it from the jury's point of view. They're following the instructions. They're going down this list like they were told to do.
There were multiple allegations made by the state of how the homicide could have been committed. There was a proper definition of knowingly. There was at least a partial proper definition of intentionally, and then presumably an improper definition of intentionally. How are we to know which definition the jury used in deciding that he was guilty of murder?
Well, that's what I'm saying, Your Honor. We're looking at it from the jury's point of view, and how are they going to look at this? They're going to look at it like they were told to. They're going to take it in order. And the very, very first thing that they see is intentionally. And it just makes sense that they would go back and say, okay, how do we show that he did it intentionally? And if they can show through the improper definition of intentional that he was guilty of murder, then they're not going to go on to knowingly. And they're certainly not going to go on to manslaughter or criminally negligent homicide, which were the other two choices on the jury verdict form, on the verdict form.
Well, counsel, what I think the judge's question gets to is this Court of Criminal Appeals discussion of whether or not this is theoretical harm or actual harm. And how would you characterize what is the harm, and then what is the character of that harm? Is it theoretical harm?
The harm is a potential incorrect verdict. When you are able to decide a case on the very first point, and that first point has an incorrect definition that allows you to decide the case that way, then you don't go on to the others. It just makes sense. You don't go down. It's not theoretical. It's something that happens. We assume that the juror followed the instructions of the court and went down the list.
But as the judge and the state points out, there's 4 grounds or 4 methods by which murder could have been found by the jury in this case, properly so, based on the definitions, and one method of murder that is arguably improper, and that would be intentional by the nature of the conduct, that he admitted that he was strangling this woman, but that it was not his intent to cause the death. So that's where the definition of intentional obviously comes into play. But and I think I would at least interpret your brief to concede that there was sufficient evidence of murder on some of the other theories, but this was a theory of murder that was improperly included in the charge. Why is that not theoretical harm?
I think because, Your Honor, as I said before, the order that it was in, it was the very first thing they looked at. And the fact that the charge was written so that they didn't go further. Once they found that he was guilty, they stopped. And there is a concession, yes, that one of these he would have been found guilty of. It may not have been murder. It may have been manslaughter. It may have been criminally negligent homicide. But the fact that the jury was not even allowed to get there because of an improper definition is what caused the harm.
Okay. John, I don't know if I teased out the edges of the analysis that we needed to talk about. Was there anything else did you want to probe that any further?
No, I'm good. Thank you.
Okay. Judge Johnson, anything?
When you refer,
go ahead.
When you refer to the order, are you talking about the order of the lesser included charges? Are you talking about the order of the definitions of intentional?
I'm talking about the order of the charges, the lesser included charges, of course, they weren't allowed to get to, but also the order of the very first instruction. They're finding guilty of murder. And then when you look under 6, it says, did in there intentionally or knowingly cause the death? And so the first thing you would have looked at is just common sense. The first thing I would have looked at would be, reading that way, is, okay, let's look at intentional. And okay, yeah, he engaged in the conduct, and he wanted to engage in that conduct. So that's all we need. And we stop there. And because that's what the court has told us to do. We don't have to go any further. We don't have to consider, we don't have to consider knowingly, because we've already found intentionally. And so we go down and we never get to the lesser included charges. So
were they made conditional, or were they just put out there as other alternatives?
They were made conditional. It says if you when you look at the bottom of number 6, after it talks about the murder on page 3, it says, if you do not so believe, you will acquit the defendant of the offense of murder and next consider the lesser included of manslaughter. So if you found murder, you didn't find manslaughter. And when you look at the verdict form, and I have it here, but they signed off on the guilty of murder, and then everything else is blank. So they obviously didn't go any further.
So it had the conditional language required that they acquit before they consider the next.
Exactly.
Okay.
And to be clear, and to kind of tease that out, the charge did not make the various methods of finding murder serial or sequential. It was intentional result, intentional conduct, or knowing conduct.
Yes, it was, and that we're just looking at the common sense order. The first one is intentional, and there would be no reason with that definition being so clear and the evidence being so clear that they would ever go any further than intentional. There was no need.
All right. Anything else you want to sum up?
No, Your Honor. I believe that we've hit it all.
Okay. Thank you. You'll have 5 minutes for rebuttal.
Thank you.
Counsel, you may proceed when ready.
Please the court. Jonna, can you hear me?
It's kind of hard, so please speak up.
Let's see. My technical advisor just left the room.
That's all right. I haven't gotten your name positioned yet either. So.
All right, are we better?
Yes.
Okay. I'm going to start off throwing a curveball. I know in my brief, I attempted to argue that there wasn't jury charge error based on the court of criminal case of Lugo versus State. I tried to make a distinction because under 1902 B2, the court indicated that both nature of conduct and result of conduct elements are, are embraced by that statute. Having had time to look over this since then, I've changed my position. I do believe there was jury charge error. I think in the dicta of that case, and that was a defective indictment case, not a jury charge case, that they cautioned or they emphasized that murder is, regardless of what theory you allege, it is a result of conduct offense. And they caution putting a culpable mental state attached to the committed an act and clearly dangerous to human life, because they said that would run the risk of creating a hybrid type offense and moving the gravamen of the offense from the intending to kill or intending the result onto intending the nature of conduct. So I changed position on you, but I still believe that it was harmless error.
Well, in discussing the harmless error, the first thing that I asked opposing counsel was, do you see a difference in the standard as historically articulated by the Court of Criminal Appeals from the O'Valley case forward, repeated frequently by this court, that there is no burden to show harm? There is a duty on this court to determine if there is harm, versus any change in that position that might have been signaled by the Court of Criminal Appeals, that there is a duty to show harm by the person asserting it, obviously most often the defendant. Do you think there is a distinction, a shift? And if so, does it matter in this case?
Actually, I'm not aware of that case and that shift. I apologize, but I would say it really didn't make a difference. Overall, or ultimately, you have to decide whether or not there was actual harm, whether she shows it or y'all decide upon it. And in this case, that can't be done because, well, as y'all discussed earlier, under Article 3707 of the Code of Criminal Procedure, when you have one offense alleged, but you've alleged it under multiple theories, then the verdict has to be general. So the jury is deciding, yes, he's guilty of murder, or no, he's not guilty of murder, and you're not going to have separate jury forms for each of the theories alleged. So there's no way of knowing what theory, what culpable mental state, what definition within those culpable mental states that they relied on in coming to their verdict. They very well may have all 12 jumped on to knowingly cause the death of the victim. And as you said, that was properly limited in the definition of knowingly to result of conduct. So, I mean, how are we to know? And based on just speculation, you certainly can't. If that's what actually happened, how could you pull that verdict away from them just on speculation?
But you do agree that there is one theory of liability as defined in which he could have been convicted for murder that the law does not allow.
Correct. That was one of the four options of finding the fact that it was his conscious objective desire to engage in the conduct. Therefore, we find him guilty of murder. He choked her, so he's guilty of murder. That's a possibility. But it's highly unlikely because of the language in the application paragraph and the focus of the state's theory of the case, the evidence adduced in support of that theory and their closing argument, all limited the jury's focus only on result of conduct. If I may continue along that, the language of the application paragraph tracked that of the indictment, which in turn tracked that of the relevant statutes under 1902 B1 and B2, dealing with the theory that defendant intentionally caused the death. Well, the term intentionally directly modifies the result of conduct, the caused the death. And so as far as the nature of conduct, that wasn't even alleged under that theory as an essential element. That was manner and means. And so therefore the nature of conduct definition of intent would not be applicable under that theory. And then under 1902 B2, there's only one culpable mental state mentioned, and that's in association with the result of conduct that's with intent to cause serious bodily injury. There is no culpable mental state attached to the verbiage or the phrase committed an act clearly dangerous to human life. So the jury attention would not even go there. So that nature of conduct definition of intent would also be inapplicable in that situation. And so that, therefore, if jury charge error, which I believe there was, it was harmless because the jury, by the language of the application paragraph was limited in their focus only to result of conduct. I mean, everything points to that, as well as the state's case evidence in their closing argument. And I mean, you're well aware of the facts of the case, and the closing argument. I mean, basically the state was going from an escalation from fantasy one, where, he wanted to choke a woman while having sex with her, which would be nature of a conduct offense, to continuing that behavior up until, during, and past the point of her passing out, still nature of conduct type offense. But that's not what we alleged. This is a murder case, and the the whole focus of the state's case was, or their theory, is he was escalating, and he's an opportunist. He when he sees a chance to go up to the next fantasy, you know, he takes it. Their point was, okay, you've choked her for, I think Dr. Pawani said, take about a minute of constant pressure simultaneously on both carotid arteries. If you do that, they'll pass out in about a minute. Well, the state's theory of the case was, and the focus in closing arguments is, why continue doing that for another 2 to 4 minutes, which Dr. Pawani said was necessary to bring about death? I mean, she's already passed out. So, and as in their closing argument, which I thought was really well done, is the prosecutor strangled the imaginary neck of Alexandria Wright and took the jury through the timeline. Actual 5 minutes in front of the jury, and what had to be very awkward and uncomfortable, to the point where she's wondering before a minute comes up, what have I gotten myself into? To where she's now panicking, she passes out, and then for another 4 minutes, he strangled that imaginary neck. And the point was to bring everything together to show that it was his conscious objective and desire to cause the death, to get that ultimate fantasy of necrophilia. His fantasy, not mine, but that was, so between the state's evidence, their closing argument, their theory of the case, the language of the application paragraph, nothing points to the jury to look to nature of conduct definition of intent in deciding, well, okay, he must be guilty of murder. So
the only defense that he had to murder was that he did not intend her death. The charge negated that opportunity, that defense, because with the charge as given and the admission that he intended to choke her, there was no way that the jury could have avoided, in effect, if they had applied the evidence and the law, and find him guilty of murder, because there wasn't the opportunity for the jury to say, yes, he intended the conduct. No, he did not intend to murder her. How do you square that with the error in the charge that allowed that as not being actual harm, when his only defense to the difference between murder and manslaughter, which obviously has different punishment ranges, or at least different approach to the punishment, that the state took that defense from him by the way they defined intentionally?
Well, again, I don't think there was any wiggle room for the jury to consider anything but the result of conduct definition. I mean, you know, the language totally took the nature of conduct definition of intent away from them. There was nothing that said at all to say consider this, just by the language itself. So, and as far as actual harm, again, I don't see how you can prove which of the theories they relied on. I mean, it could have been split. They all could have been on one.
But we know that they could not have relied upon the fact that he did not intend to kill her, because that was taken from them. And that was his defense to murder.
Well, I'm not sure I understand how it was taken from him, because they could have, looking at the definition of intent as it applied to the law and facts, I mean, that was a decision he could have made.
He intended to choke her. We agree?
Correct.
She's dead. We agree?
Right.
The question is, did he intend to kill her by choking her? That is what is eliminated by the definition of intentional, because the cause of death no longer has to relate to causing the death. He only had to intend to choke her, and that caused her death, even if he didn't intend to. And that's what makes murder murder, is that you intended the death.
Correct, but I'm still not following how the jury would even consider that option.
And let me ask you, is that because what you said earlier about that you think the application page limited the definitions, even though the general definitions included an improper definition, that the application page fixed that problem?
I do.
Okay.
I mean, like I said, when you're dealing with 1902 B2, and going back to Lugo, there they said, that if you include that definition of the culpable mental state of intent or intentionally committed an act clearly dangerous, then you are shifting the gravamen of the offense, which is result. So you can include it. And if it's not included, how could they consider it? So all it says is, I intended to cause serious bodily injury. I intended the result of my actions. And it really faces no focus on the action itself or the underlying conduct. So there would be no consideration. Their focus would be solely on, did he intend, what is his conscious objective desire to kill her? And the choking, under the 1902B1 was just manner and means. So it wouldn't have been available to them to consider. So I don't see how they even get there. That would be a consideration. But and I think it would be a mistake to make that available for them to consider that in a verdict form.
Then there wouldn't be error in the charge, but you've stipulated that it was erroneous.
I think there was error in charge. There was just a definition of intent that really was not applicable to the facts and the law. But then, as case law always comes back, is, did the application paragraph limit the jury's attention only onto the appropriate definition? And in this case, it did. And that's why I feel it was harmless.
Anything in closing?
No, other than, I said, if jury charge error, I feel for the reasons, I just discussed, it was harmless, and therefore the issue should be overruled and the conviction should be affirmed.
Judges, any more questions?
No, sir. Thank you.
Okay. Thank you, counsel. Counsel MacArthur, you may, well, let me get the timer fixed here. You may proceed when ready.
Thank you, Your Honor. Your Honor, I think the court was correct when they, in something that I maybe inartfully tried to explain. Even if they considered the other theories of murder and found them lacking, they would have gone back up to that definition of intentional, because that they did, it was undisputed. He did intend the nature of the conduct. And so they could have gone through all of them and found him lacking. and he still would have been found guilty of murder, and it would not have allowed him ever to get to the lesser included offenses. And I think if you're saying, well, does that cause harm? Well, yeah, it does. And you mentioned that they had a different range of punishment for the manslaughter. It's 2 to 20, and for the criminally negligent homicide, it is a state jail felony, so it's up to 24 months. And with his criminal history, they could have even given him probation. So what we're looking at is a young man, he was 28 years old at the time, who, because of this incorrect definition, was found guilty of murder and sentenced to life imprisonment, where he's not eligible parole until 2049. And
Well, you say because of an incorrect definition, he was found guilty of murder. How do you know that?
I know that it doesn't matter what the evidence shows on on the result of conduct. I know that there was evidence on the nature of the conduct. It was undisputed. And so you've taken away, by that definition, the jury's consideration, even ever getting to the lesser included charges. There was no way they could get there. None. So I can't see where that isn't harmful to the defendant. And might they have found him guilty if they had continued the analysis of one of the other charges? Yes, they may have, but they didn't. They stopped. And I think that if we're wanting to see justice done, then we have to make sure that that the definition of intentional is correct in this case. And it was not. Now, the state seemed to be arguing a sufficiency of evidence issue, and I'm not sure why that was, but this jury charge negated those two lesser included offenses on the jury charge, and I believe that Chief Justice Gray is correct, because even if they considered the other theories of murder, they had to find and found him lacking. They still had to find him guilty because of that incorrect definition of intentional. So no matter what they did, they were going to have to find him guilty because he had admitted to the nature of the conduct.
I take it that you think the application paragraph didn't eliminate the incorrect instruction.
No, I do not, because the application paragraphs still talked about did, then and there intentionally or knowingly cause the death. That's the first thing they see. Now they have all kinds of ways that it could have happened, but again, you're going to go back. How do we find out? How do we know if he did it intentionally? Well, we go back to the definition of intentional given by the court. And so, no, it doesn't negate it at all. It repeats it. Did that answer your question? I'm sorry.
Yes, ma'am. Thank you.
Any other questions from the judges?
No, sir.
Counsel, got anything else?
No, sir. I think that we've covered every bit of it, and if nobody has any questions, I want to thank you guys for listening, and I appreciate you giving this case the extra consideration that I feel it deserves.
Thank you, counsel. This
Thank
case
you.
is submitted and y'all are excused. We will take about a 5-minute recess at this point, and we'll come back to the last case of the day, which I have here on my desk somewhere, and it'll give me an opportunity to find it. Dupliced versus Nimbus. So we'll be back in about 5 minutes. Thank you.
Thank you both. Appreciate it.
Thank you.
Gentlemen, we'll wait for the other two judges if you don't mind.
No worries, Your Honor.
We'll call this the the bearded lawyer club right now.
Hey, and very limited hair.
That's right. Although although you have the most of the three of us.
Hey, it's just, I can't say wiser, but I can say older. So. Yeah, I think when at one of the recent arguments, I noticed that it was the first time that I think two panel members at the same time had some facial hair. And so, we're going to have to get Matt on the program here, Matt. I mean, you're the only one on screen.
Yeah, I know.
That's right.
So, all right. Well, gentlemen, we've had murder and mayhem, and now we're going to talk about dirt. So let me get you up on the time. Is everybody ready?
Yes, sir.
Got a thumbs up from everybody, so Counsel Ruttinger, you may proceed when ready.
Thank you, Your Honor. And I just want to make sure everybody can hear me okay.
We can. It's got a little bit of an echo in it, but it's not bad. It's prevalent in an empty room. So you go ahead.
Understood. If I need to slow down or repeat anything, please just flag me down.
If my eyes glaze over, you might want to repeat.
Perfect. Thank you, Your Honor. As you mentioned earlier, and as you said right now, this is going to be a dirt and probably a little less exciting than the two cases we've had before. But Your Honor, this is a case about trying to get into the courtroom, whereas the last two we've seen were once you're in the courtroom and through to the jury charge. So this is that opportunity to get in the door and to hear a controversy heard by the trial court and to try to get a ruling or a determination on that dispute. Just to give a little bit of a factual background, this does involve a restrictive covenant, a deed restriction on two pieces of property. The original plan for the subdivision was filed and designed in 1923 and then was filed in the official property records. The first deed was in 1927, which was on the property owned by Appleese, which I will refer to as Nimbus just for ease of conversation. And they eventually purchased it, but this was the first sale to them in 1927, and it contained a deed restriction in the deed that said churches, stores, theaters, schoolhouses, and other central meeting places shall be constructed only on lots provided in the plan for establishments of that kind unless agreed to by the board of directors of said company. There was a typo. I went ahead and took that out for just ease here. 15 years later, we have the original deed to appellants, my clients, who I'll refer to as the Dupliced, and it was to their successor or a predecessor in interest. And in 1942, it was sold to them, and it contained the same deed restriction in that deed as well. 5 years later, in 1947, the Southside Development Company, who had established the plats and it was the I guess enforcing agency at that point in time, as to this restriction, dissolved, and there was an assignment as part of that dissolution that assigned their rights and privileges to waive or remove any of these prohibitions and restrictions to 5 individuals: F.B. Clark, C.W. Burchard, Eleanor Scotes, and R.R. Lancaster. I guess that's 4 individuals. And this was recorded in the official records also for Brazos County. Now we fast forward quite some time to 2015 when Nimbus purchased the property at issue in this matter. And about 18 months after that, they filed a zoning application with the city of College Station to rezone their plat and their piece of property from residential to general commercial. And this zoning was approved and moved forward, which led to the Dupliced filing this lawsuit ultimately to get a declaration regarding the restrictive covenant and the deed restriction that I mentioned earlier that was in that deed, to try to see if it was applicable and to determine if that was going to limit what Nimbus could use that property for. In August of 2018,
Let me
I'm
interrupt.
sorry.
What relief were your clients seeking from the trial court?
Yes, Your Honor, they were seeking a declaration as to the enforceability and applicability of the deed restrictions. We weren't trying to enforce the deed restrictions. We were just checking, and it was seeking a declaration from them under the Uniform Declaratory Judgment Act that these restrictive covenants were enforceable on this property and had carried forward from that original deed in 1927 at that point on the Nimbus property to the Nimbus ownership currently.
Which sounds perilously close to an advisory opinion from the trial court to me.
And I can see where the trial court felt that way, and the trial court did agree with that in its September 18th email ruling that it sent, and it used those exact words, that this was an advisory opinion because it found that there was not an actual controversy in place. I would argue, and my clients have argued, that this is a justiciable controversy here, and it is right for determination. And if you'd like, I can go ahead and jump right into the rightness argument, and we can circle back to anything else. But I do think that's kind of where the rubber meets the road, so to speak, on this dispute. As the court's aware, rightness is an issue of when and not who may bring a lawsuit. And timing means everything. But under the Declaratory Judgment Act, a party may petition a trial court for rights under a written instrument. And Texas courts have held that the validity, applicability, and enforceability of a deed restriction is appropriate under a declaratory judgment to seek what determination of those rights can be in a declaration for those rights. What you have to look for in a declaratory judgment is, as Justice Neal, you noted, any declaratory judgment starts getting into that advisory opinion area quickly because you're asking for a court to make a declaration of something that might happen or is going to happen or is imminent. So that's why courts have determined that for a justiciable controversy for a declaratory judgment, and as the Austin court noted, what you're looking for is the presence of ripening seeds of a controversy, something that has imminent threatened litigation and just seems unavoidable at that time. And I think what we have here is that exact situation. We have Nimbus, who openly and overtly has petitioned, gotten the residential property rezoned to open a store, which is in direct contravention of the deed restriction, as was noted, where it prohibited churches and stores on that property.
But if you don't want to enforce it, why get a declaration?
Well, Your Honor, I think this will resolve a justiciable controversy, because if the court determines that these deed restrictions are applicable, which we argue that they are, then the only thing that would make an enforcement an issue would be if Nimbus was bold enough to thumb its nose at the declaration of the court and willing to go ahead and put a store on that property anyway, in direct contravention of the court's decision that the deed restriction was enforceable. So what we have here is a justiciable controversy. What we've done at this point is we've, frankly, for the economics of it, as opposed to having Nimbus get construction loans, pour a slab, and we're moving down the line of construction where you're going to have to take that down if the deed restrictions are enforceable, or you're going to have to take that off the property, or we're going to have to figure out a solution to that. What this does is we came to the court and said, make sure that these are enforceable so that Nimbus knows its rights, and so that we also, as the Dupliced, who live just down the street, know what our rights are under this, as well as the deed restriction there, so we can determine if there is going to be an issue, down the line. Now, I understand where that does start to blur that line, but again, as a corporation and as a citizen, I would think that a declaration of the court at this point in time saying these deed restrictions are enforceable on the property, they're not going to go run and build a church, a store, a theater, a schoolhouse, or anything in direct contravention of that deed restriction. You run into a res judicata, collateral estoppel claims on top of that as well. So I believe that we do have a justiciable controversy here that was right for determination, especially under the Declaratory Judgment Act, where you're looking just for that inevitable litigation that's coming, an inevitable conflagration of these two parties, and everything we've seen from the zoning application and everything else, we were coming to a loggerheads on this issue.
What else are you referring to? I mean, we have to have some seeds here of a controversy. Lay those out for us. What were all the
Certainly.
steps that were being taken?
Certainly, Justice Johnson. What we had in the record before you, and primarily, I think the largest and the most the largest piece of evidence and what we can look at is truly the zoning application that was filed. And you can find, and if you bear with me, I will find the zoning applications in the clerk's records 57 to 75 for reference. And what Nimbus did was they filed through their architect to get the property rezoned from residential, which is what it's currently zoned, to general commercial. And in the application, their request is so that they can develop and operate a retail store. So they have openly and overtly said, we are going to build and operate a retail store on this property, which would be in direct contravention of the deed restriction that was contained in the original 1927 deed that then ran with the property up until their purchase in 2015. And to me, that's the ripening seeds of the controversy there, is they haven't hidden, they didn't get it zoned for general commercial and wait and see what would happen. We have filed documents that show that they were filing an application to get it zoned to develop and operate a retail store, which just happens to be a few hundred yards from the previous location that they're operating at that was looking to get closed because of road construction and other things. So everything was pointing towards Aggieland Outfitters, which is Nimbus Properties company, was going to be opening its new location just down the road on this new property that it bought, had gotten rezoned for commercial use, had gotten it rezoned to develop and operate a retail store. So those are the ripening seeds of the controversy that we have there that really, I think Judge Smith didn't see when he made the claim that there wasn't an actual controversy there, because he goes as far as saying that we're not saying that you can't file a lawsuit to try to enforce this later. We're not making any opinion on that. Whereas I think he missed what the Declaratory Judgment Act provides as an opportunity for us to get a declaration regarding our rights under those deed restrictions and under the enforceability of those deed restrictions. And really, economics for the parties, economics for the court, economics for everybody. The time to find out is now, before we've all expelled a lot of money in trying to prevent construction on the property, having gotten construction on the property that now is going to be in violation of the deed restriction. And you can even go, further and further down the line of what that would cost. This really, much like parties in a contractual issue, and they're looking at what's about to happen, and they say, I need to get my rights under this contract to determine what's going to happen when XYZ occurs. This is a very similar instance here in what you see declaratory judgments for in a lot of different ways. We need to know what's going to happen when they put Aggieland Outfitters at 100 Fairview Avenue. Fairview Drive. So we need to know what that's going to do. Is that deed restriction going to prohibit it? And that's what we're seeking the declaration on. Again, I know that we haven't had them put a shovel in the dirt, but they've done everything but park a excavator on the property and start digging to lay a slab.
Counsel, I think somewhere in the pleadings or in the briefing, there was a reference to the fact that y'all had not sought an injunction against them turning that first shovel of dirt or pouring the slab or proceeding with the retail store. And I can't get inside Judge Smith's mind, but that seems to be a different level of confrontation than simply what does it mean or what does it say? And this is not about your track. It's not, can I do this with regard to 400, whatever the name of the street was, but it's what somebody else can do. And I guess what I'm asking in a very crude way is, if this is where it stays as not a justiciable interest at this time, can you amend your pleading such that there would be one?
Your Honor, I think we could. I think you're right. Part of the reason, and strategically part of the reason, and hindsight being 2020, maybe an injunction was something we could have sought. But at the time when we filed the lawsuit, as Chief Justice Gray, you noted, there hadn't been a shovel in the dirt. There wasn't anything there. It didn't preclude us from immediately running down to the court and filing an injunction if they went that far. Again, this was really my clients and us trying to be as economical as we can of let's get all our cards out there and figure out what needs to happen now, what can happen in the future before we get down that road, before you have to put something in the dirt, before we have to run down to the court and try to seek a TRO and get a TI and go through the rigmarole. This is really, we've got those ripening seeds, as we noted earlier. We're going down that road. We don't have a need to get the injunction. We don't want to have to worry about bonding. We don't have to worry about those types of things at this time because those just haven't presented themselves yet. But we still have a justiciable controversy under the Declaratory Judgment Act. What we have is the opportunity for the court to determine what are our rights under this deed restriction. I do understand that this is someone else's property versus our property, but Nimbus has gone every step of the way but putting that shovel in the ground. So this wasn't us going 80% of the way and we're trying to ask the court to go 20% of the way. We're 99% of the way to a retail location at 100 Fairview, and we want to determine if that's going to be in violation of this deed restriction. And that's why we went to the court and asked for the declaration as to what our rights are under the deed restriction and what can be done on that property. So that's kind of the route we took. I don't think that it would preclude us from coming back and getting an injunction. I don't think it would preclude us from amending to get an injunction, and it would definitely tee up the issue as to the applicability sooner through a TRO and the TI process. But what it does is it just gives us this was the most economical way for us to get this issue in front of the court for both parties, for the court, for us to get a determination on a justiciable controversy under the Declaratory Judgment Act.
Because this does involve more than 2 lots, I assume, because there was a development and there are other landowners, I assume, between 100 and 400 Fairview. Are they necessary parties to this proceeding? Because obviously, whatever the court were to say about your lot or their lot might impact everybody's lot that has this restriction on it.
I apologize for interrupting, Your Honor. I do not think that these are necessary parties. This is a declaration as to the deed restriction on 100 Fairview. I do think it has overarching implications as to other properties, but I don't think they would be necessary parties to this, because it's not, if it's effective and is going to stop any action on Nimbus property, it's going to stop any actions on their property, it's going to stop it. If it's not going to affect Nimbus property, it's not going to affect their property. So I don't think they would be necessary parties per se to this proceeding. I would think they would be interested. I think they'd be following along with our litigation. It's just my clients were the ones that were willing to take the step to see the applicability of these deed restrictions versus the neighbor, because you're correct, there are multiple lots, and there are lots of other lots in this neighborhood that have the deed restriction in place. But I don't believe they would be necessary parties per se for the declaration we are seeking as to Nimbus property.
And I don't remember which of the judges asked the question, but we circumvented a very large portion of the briefing, which is about the procedural posture of this case and whether or not we are in any way limited by anything in addressing any reason that this case is not properly in the trial court. Will you agree with that characterization?
Yes, Your Honor. I briefly had mentioned the email that we got from Judge Smith. And as you saw in our briefing, and I will try to summarize briefly here, our position is that those were the findings of fact pursuant to Rules 296 through 299A of the Rules of Civil Procedure, which kind of sets the bounds and sets what the trial court looked at when it made its determination. And if you look at what Judge Smith said regarding an advisory opinion and that there was no actual controversy, rightness really is what the judge hinged his determination on. Now, we also recognize, and as we mentioned in our reply brief, that subject matter jurisdiction can be raised at any point in time. It doesn't mean that even on appeal above the 10th to the Supreme Court, it could be briefed for the first time and be raised for the first time. So we are cognizant of the fact that if subject matter jurisdiction isn't there, be it ripeness, be it justiciable controversy, be it standing, which we also addressed in our reply brief as well, that we don't have the ability to narrow the court down on that. Now we can narrow the court to subject matter jurisdiction as per the email correspondence. But we do believe those are the findings of fact. There's a case, I would reference the court to In re Estate of Miller, which is from, I believe, our original appellate brief that discusses the necessities and the necessary requirements for a findings of fact to be filed of record, to provide a detailed explanation. Very similar facts to our case here that Judge Smith did, where he detailed what he looked at, what he'd examined, what the findings of fact were, filed of record, didn't file anything afterwards to supersede it. The judgment was also filed of record. So it's our position that this does constitute the findings of fact. And then just briefly, Your Honor, I would say that as to standing, and I will come back and answer any questions that you may have regarding that, or I can also address it in my 5 minutes rebuttal. The plan, the general scheme that Southside Development had set up shows that these deed restrictions from one deed in 1927 to the same deed restriction in 1942 shows and evidence that these deeds were designed to run with the land. They were designed to provide the other grantees the opportunity to enforce it. I would direct the court to another case we had cited, which was the Ski Masters of Texas, which discusses these general schemes that are filed and general subdivision schemes that these use, that neighborhoods use in Texas all over the place to enforce their deed restrictions, and what they do with these general schemes and limiting what can go on certain plats and what can go on other plats. That you have an implied mutuality of covenants that gets these opportunities to come through and grantee, and in this case, would be priests, to enforce onto another piece of property, because under their restrictive covenant, they have the benefit to the other restrictive covenant. So if you have any other questions, Your Honor, I'll go ahead and cede the rest. I know I appreciate the extra 2 minutes, but I'll go ahead and cede the rest of my time.
One question I do have, because it kind of touches on that enforcement, and you made a statement earlier, and I didn't want to interrupt your flow, about the Southside Development was the enforcement mechanism, but in what I saw, Southside Development was the kind of the permission to alter, and that there wasn't a specific delegation to anyone or any entity to do an enforcement.
Yes, Your Honor, and I will admit, as soon as it came out of my mouth, I realized that I had chosen my words poorly on that. You are correct in noting that Southside was provided the opportunity to lift the restrictions that were in the deed restriction. Enforcement wasn't assigned to any particular entity or any particular corporation or landowner. So what that allows is, as long as those deed restrictions are pertinent to the property, which we argue they are as part of the scheme and as part of what Southside had set up, the grantees, later grantees, successor grantees, such as my clients, the priests, have the ability to enforce those.
So under general common law, anybody that benefits from the restriction is also authority to enforce it.
Yeah, yes, Your Honor. If you're the beneficiary of the restrictive covenant, you have the ability to enforce it.
Okay. Judges, anything before we hear from the other side?
No, sir.
No.
Counsel, you may proceed when ready.
Thank you, Chief Justice Gray, Justice Neal, and Justice Johnson. Thank you for the opportunity to present oral argument, and for the folks at Sam Houston State University, thank you for your attention. My name is Matt Doss. I'm an attorney for Nimbus Properties LLC. was trial counsel in this case and handling the appeal today. I don't want to spend a whole lot of time on the facts, but I do think there's some important distinctions that we need to discuss that relate to the appeal. Nimbus property, and I'm going to call the 100 Fairview the property in question that my client Nimbus Properties owns, and I'll call it the Nimbus property. It's at 100 Fairview on George Bush Drive, which is at the time was probably just a horse and buggy road back in 1923 when the subdivision was formed. Maybe a Model T or two going down the road. Now is a 5-lane road with multiple bike lanes across from one of the largest football stadiums in the United States. You know, from that corner, from that property, you can hit a 5-iron possibly to Kyle Field. You've got multiple commercial properties all around it. We're not talking about a property, you know, an individual trying to build a store in the middle of a neighborhood. We're talking about a property that is on a commercial thoroughfare even within the subdivision. There are properties starting with St. Thomas Episcopal Church and preschool where I attended as a 5-year-old, running to the Hillel Foundation, a Jewish student foundation, to the Mormon student foundation building. And then a convenience store and gas station that's in the
Counselor, will the record show, and I'm not sure that it matters because that's getting into whether or not there's been a general degradation or waiver, other things that may or may not apply to. Is the record going to show, however, that those properties and businesses are on land that has similar deed restrictions on them?
Correct.
Okay.
They will. And a counsel for the Dupliced mentioned that the restrictions prevent the construction of a store on the Nimbus property. That is incorrect. As you noted, Chief Justice Gray, that there is the right to construct a store if the board of directors of said company agree. And that's an important distinction because said company is not defined in the deed restrictions. The board of directors of said company are not defined in the deed restrictions in the four corners of the McKee deed. The McKee deed is the deed from Call Station Housing Corporation. It's the first deed out from the common grantor that has these deed restrictions that have been alleged. And the company's not defined, although the Dupliced have readily admitted and judicially admitted in their motion for summary judgment in the trial court that company means Call Station Housing Corporation, which ceased to exist and dissolved in 1947. Southside Development Company, another entity that's mentioned in there, also ceased to exist. I think in Southside was in 1947. Call Station Housing Corporation ceased to exist in 1943. What's important about this is that the deed restrictions do not provide in the four corners of the deed that these restrictions run appurtenant to and bind the heirs, successors, and assigns of J.R. McKee. They do not provide that any other lot owner or entity can enforce or bring any action associated with the restrictions. They don't even mention any other properties other than the property in question, which is the Nimbus property, which is really important. And this is one of the things, Chief Justice Gray, you mentioned the common scheme, and Mr. Redinger said that if there's just a general scheme, what we're talking about here for standing, because there are multiple, as you guys know, there's multiple components of subject matter jurisdiction: standing, ripeness, mootness, and justiciability, which I'll call that advisory opinion. As Justice Neal noted, the claim, we want the court to tell us that these are applicable to this property. What are you asking the court to do? You're asking the court to give you legal advice. That is asking for an advisory opinion. That is impermissible under the law of the state of Texas. it also goes to ripeness because you're not trying to enforce it. You're not using the Declaratory Judgment Act as it's meant to do to enforce deed restrictions, to resolve a controversy. They're not trying to resolve a controversy. They're just asking the court to provide, the trial court to provide legal advice. Judge Smith, although he may have some very profound and strong opinions about this matter, cannot provide legal advice. He can only make decisions regarding facts and law that are presented to him. The deed restrictions, they don't even get to first base here. We don't have to talk about ripeness or just disability advisory opinions because the priest nor anyone else in College Park will ever have the right to enforce the deed restrictions against this property because the restrictions were personal. This is a title issue. As Chief Justice Gray mentioned, this is about dirt. If you do not have express language in a deed with regard to these restrictions, if they run pertinent to the land and bind heirs, successors, and assign, or otherwise express that intent, it's a personal restriction. In other words, this was a restriction between College Station Housing Corporation over here and J.R. McKee. We know College Station Housing Corporation has ceased to exist. And so we don't get to first base because the Dupliced never had a right to bring this lawsuit. That's what the basis of our motion to dismiss involved, the amended plea jurisdiction. The other issue is that the deed restrictions don't provide, that goes to being a personal grant, they don't provide anybody who has authority to the event of succession of the company, whoever that is, whoever the court believes that is. The Dupliced believe it's College Station Housing Corporation. They stated that in their summary judgment motion in state court. That's a judicial admission under prevailing Texas case law precedent. So you can take them at their word for that. But the issue there is that there is no method of succession. And you may be familiar with the TAR case that came out in 2018 that dealt with deed restrictions. And that was a case that dealt with the fact that there were some folks in San Antonio that wanted to rent their house out for Airbnb. And then there's a Davis versus Huey case. And these are cited in Nimbus's brief. You are only bound by what's in your chain of title. Actual and constructive notice. Constructive notice is what's in our chain of title. That's all we have to be concerned about.
But your chain of title has this limitation on what you can do with the property.
It has a limitation that is unclear, that is vague, and does not provide for a successor or any restrictions, and it does not provide that it runs beyond those original parties.
Then why on earth would you and your client not want to clarify whether or not this applies before you go build $1 million building on it?
We didn't bring the lawsuit. The Dupliced brought the lawsuit, asking for an advisory opinion and without even a right to do so. Our argument, without involving several hundred property owners and college students that may live in those properties, which they do. And this is, like I said, just across from campus. Mr. Ruttinger is correct. It is a expense issue, although I don't know that it was really that cost efficient for us. My client incurred more than $40,000 plus his appeal costs to get to where we are. What we hope to do was resolve this dispute with regard to the Dupliced because no one else has come forward. Gaines Wesley counsel for the Dupliced actually filed a motion. You'll see in the record, he filed a motion to have the court advise whether or not a party should be joined. The court decided that the other parties and the other neighbors in the subdivision did not have to be brought in, although he still served them written notice of the lawsuit. Nobody intervened. Nobody was joined. The individuals who were mentioned that Mr. Ruttinger mentioned about Southside Development, those folks weren't joined. Their heirs were not joined.
But doesn't that all speak to the fact that there is, and maybe we don't get to that under your theory, but that there is an actual controversy involving whether or not you can build this building without violating a limitation in the deed. And do you agree that we have to look at everything on jurisdiction, that we're not procedurally bound at this juncture by standing, ripeness, mootness, justiciability? If we don't have jurisdiction, it's in front of us.
It's always in front of you, Judge. But I would say this, going back to the email, that is under this court's past precedent and the prevailing case law in the state is not a findings of fact and conclusions of law. There was no.
It doesn't even matter.
Because
we're talking about jurisdiction here.
It does matter to this extent, Chief Justice Gray. It does matter for briefing purposes because the Dupliced have waived their argument to respond to the jurisdictional arguments that were alleged in the trial court. The order was granting that motion. They chose not to brief that issue before the court. They cannot raise it in a reply brief the first time because it was not raised in their brief. It doesn't even matter that
but it's jurisdiction. You can't waive it.
You cannot waive it to raise it if you're trying to deprive say the court does not have jurisdiction. They're the ones that are asserting the court does have jurisdiction. And I think that's a really important distinction here is that they waived their right to challenge our arguments. And so if the court finds that any basis that we had for lack of jurisdiction, specifically standing, then they lose. They lose on that alone. Now, the merits of our lack of jurisdiction argument are correct. They did not have standing to bring the claim. The claim doesn't make, in all due respect, and I don't mean this to be, well, I'll just move on. The claim does not make sense. As Justice Neal noted, why are we here? What is the purpose of this proceeding? We're not trying to prevent them from building a store. They're not trying to seek an injunction. They're not even, you didn't even hear Mr. Ruddinger say today, and you're not going to find anywhere in the brief that they're even injured. They want a legal opinion that if this is applicable to our property, there's not any question, it's not even disputed that there is a deed restriction in the Nimbus property chain of title. It's not a dispute. So what does applicable mean? Your guess is as good as mine, to be quite frank. But what's important for this court to understand is that we don't even get to those issues because the Dupliced nor anyone else in College Park will ever have the right to bring a claim because the deed restrictions stopped with the original covenanting parties. They stopped there because they don't have express any language indicating intent. The Dupliced mentioned the subsequent restrictions in their chain of title. That is irrelevant because we only look at the four corners of our deed in the time. That was 15 years after Mr. McKee got his property from College Station Housing Corporation. So it couldn't form the basis of any reliance or any other grounds. There's something that he could rely on. There wasn't even a common scheme. That we did mention. Is there a
plat in the record?
The plat is in the record. The plat is actually attached to our amended plea jurisdiction and motion to dismiss. The plat does not mention deed restrictions. The deeds that are of the McKee and the McKees, in the Dupliced chain of title and Nimbus chain of title do not mention other properties with deed restrictions.
And but there is a plat.
That's correct.
So there is an area that is referred to as College Park. Is that
College Park? That's correct, Judge.
Okay.
And so to be clear about this general scheme argument they made on the standing argument, that is a red herring and is irrelevant because we're not talking about the general scheme issue would come into being if there were restrictions that passed beyond the original parties. What we're talking about here and what I've tried to, and I may not have properly briefed this or properly pled in the trial court, but what is clear is that the restrictions do not run with the land. They do not bind future heirs and successors of the sons of J.R. McKee. That would be Nimbus property. So
is that a question that is can be determined as a matter of law from what is filed in the plea to the jurisdiction, or is that a question of fact and law that has to be determined based upon the summary judgment, proof, and evidence?
It can be both. And it can be both, but most importantly, standing, because if it's personal and you're not the person, there's J.R. McKee and there's College Station Housing Corporation. And we do know that the Dupliced are not one of them. And so if they're not one of them, then then it didn't bind any future. And we know that the Nimbus, it's undisputed Nimbus, succeeded to the McKee's interest. So therefore, the Dupliced lack standing. They and nor anyone else will ever have a right to bring any claim, even if they're asking for an advisory opinion. So
what is your best case on this restriction that's in this general scheme of College Park subdivision, a plat, that does not run with the land?
Well, we gave you several cases, Judge. The first is the Billington versus Riff case. It's 492 Southwest 2nd, 343. And in the brief,
that's okay. If you tell me they're in the brief, I can find them. But
and then
I'm trying to determine why this is not a fact question that has to be developed and or resolved by summary judgment proof, because yes, there are some issues that we can resolve questions of fact in a jurisdictional sense, but if there are any disputed facts that affect our jurisdiction, the trial judge has to do that first.
And I think this court is, and the trial court has before it in the pleadings and in the record, but most notably the plea jurisdiction, can construe that deed restriction and apply the law and say you do not have standing. They're going to have to do that in this case, no matter what. In any kind of title case where you have successors and interests, predecessors and interests, you're involved in those things, there's going to be a construction. Here, this court, as the trial court, could have and sign the order agreeing that they lack jurisdiction for lack of standing, that there is that the language is not there to make this appurtenant to the land. And because of that, the Dupliced cannot and will not ever have standing. They want you to focus on ripeness, and that was admitted today because they want the ability to refile this lawsuit. My clients had to go down this road and spend thousands of dollars defending this case when the whole time they're saying, I don't want to enforce these restrictions. And we did file a summary judgment motion. The summary judgment should have been granted. It wasn't. The plea jurisdiction was. They waived their arguments. I know that I can bring up subject matter jurisdiction, but the basis of the trial court's dismissal was not, all points of error were not raised by the Dupliced in their initial briefing. They can't raise it in reply, even though I raised it. Now the court can look at the whole record, but I think this court needs to find and should find that there is a lack of standing, and there's clearly not a justiciable issue when you're asking for an advisory opinion. When you make comments in your argument to the court in a motion to compel hearing, it's not, Mr. Michelson, this is on page 21 of Nimbus's brief. It's not an enforcement action. We're not asking the court to enforce this deed restriction, just interpret it.
Again, isn't that what the deck action's about? I mean, you're fixing to build $1 million building. I've just used $1 million because nothing costs less than $1 million these days. But I mean, you're fixing to go build a building on this lot, and it seems like to me the issue is joined of whether or not that violates, and it's obviously a building for retail purposes. It seems to be an issue joined at that point, whether or not they are trying to enforce it. I mean, if there was a declaration that this restriction is binding on 100 street name, then you would be flying in the face of a judicial determination to go build it.
Well, I don't think my client's prevented from building right now, and he can and he should. But I think that the issue that I think Judge Smith wrestled with here is, whenever the question was posed, what are you trying to do? Just like Justice Neal did today, what did you want from this? Just that it's applicable. They're not trying to resolve a controversy. Is there a, we have raised the issue of standing and these other issues. I can't plead and draft the pleadings for the plaintiff and make their arguments for their attorneys and have them say the right things that erase it, but and sometimes you can plead or you can argue your way out of court. And I think that's one of the things that happened here. But that aside, even if this case is decided based on the lack of justiciability or ripeness, they, again, using the baseball analogy, they won't get past first. They can't even, the reason why you pick this case is you got the end with the jury charge and the beginning of the lawsuit. They don't get to enter the courthouse to go file this because they never, and they don't now, and they will never have the right to bring that claim. And that's why we brought it, because it was a personal restriction. Is there a controversy? This court can look at the record and decide that. They did not allege, and they still have not explained to you what the concrete injury is to them, which is part of right.
I thought it was just because it was to keep the community character of the neighborhood.
Well, that's that they talk about that. Then why didn't they bring in all the other property owners? Why didn't they say, lawsuit, we're filing a claim to preclude you from getting to constructing the store? The court could have construed that and said, yes, they can, or no, they can't, or here's what this is. Asking a court to interpret something without something being aimed at resolving a controversy is the issue. Their pleadings and their arguments in court have been the Dupliced problem, but their biggest problem, and I hate to sound like a broken record, but is
sometimes we need it. Go ahead.
They don't. The reason their biggest problem is not necessarily rightness, although it is a problem, and they ask for an advisory opinion. Problem number two, biggest problem is they don't get to first base. They don't have standing. Okay. And I think that you have the authority, the trial court authority on lack of jurisdiction to make that decision. I think that this court can do that now. I think the record and the law is there for the court to apply it. I think the case law is fairly simple and straightforward. And I don't even think that it's even disputed because of my arguments about waiver on appeal. And I don't even think that the Dupliced even briefed that issue about the appurtenance or cite any case law contradicting what we did. So I thank you for your time, gentlemen. I'm glad to answer any other questions.
Judges, any other questions?
No, sir.
Okay. Thank you, counsel. We'll now hear rebuttal from the appellant.
Thank you, Your Honor. Briefly, I'll kind of address Mr. Doss's first argument as to waiver. The rules of appellate procedure.
Let's skip the waiver, and I want to talk about standing. I'll move straight to that.
Certainly, then I will cut straight to the appurtenance issue. Your Honor, I think that we've kind of seen it and we've talked about it. It's kind of the elephant in the room is that general plan and scheme. I again would direct you. I know you asked Mr. Doss regarding his case. I would direct the court to the ski master's case out of San Antonio, and the site on that is 269 Southwest 3rd 662. And what it discusses is kind of it goes back, looks at some of the seminal cases, and then looks at the schemes and subdivision plans that we have all throughout the state. And what you have is we have Southside Development Company creates this plat, and then they go deed by deed, placing these restrictions in there as they build their plats. You don't have to have a universal plan of deed restrictions when you file a plat. You don't have to have a declarations in the record that says these plats are all that. You can do it in the deeds, and you can do it like they did, and then it moves with the land. It's in the chain of title.
What about this argument that he made about there wasn't language in the deed that made it binding on the grantees, heirs, and assigns going forward. It doesn't run with the land.
I don't believe that you have to have magic language in there to have it run with the land. What you have here is as we talked about earlier, you take the general construction scheme of restrictive covenants and you have to apply them under a contract construction. Texas Property Code 202.003 says the restrictive covenants have to be literally construed to affect the purpose of the drafter's intent. So what we have to do is we have to take these restrictive covenants and try to figure out what they were trying to do, what the plan and intent of these parties were. You don't have to go in and have magic language in there that says this goes forward. That's in there as part of this general scheme and plan that was put into place originally with the plats, with the deeds. And even if you want more evidence for it, I know Mr. Doss kind of laughed it off, but you have deeds 15 years apart that have the exact same deed restrictions in them. If anything, this shows that this wasn't a one-off deal to Mr. McKee in 1927. They were still doing the same one-off deal then, if that's the case, in 1942, and they did it on a bunch of deeds all throughout in the process, because there are other deeds that have the same deed restriction.
Are those deeds in the record?
Your Honor, I can provide that to the court. I quite candidly am not sure if those other deeds are in the record.
Okay, we don't want to supplement the record at this point, but
if I find it, and Your Honor, what I'll do is I will go back and look at the record. If there's something in there, I will direct it to the court via letter filing after this argument. But what we have there is the scheme, and I don't even know if we need to have these other deeds. Those two deeds themselves show that this scheme was in place by Southside Development Company to run these deed restrictions with the land. I appreciate that George Bush Drive has changed over the years, but that doesn't change the nature of a restrictive covenant or what you have to do regarding those. As far as the advisory opinion, I think we talked about that quite a bit earlier. I do believe we have a justiciable controversy here. As Chief Justice Gray noted as well, we're right on the steps of running in there for an injunction. We're right on the steps of putting dirt into the ground. They're building a store at 100 Fairview. That was what they asked for. That's what they asked the city of College Station for. That's what they were going to do.
Just to be clear, there's nothing at this point. I started to ask Council Doss this question because he made the reference to it. There's nothing stopping them from going and building this store right now.
As far as we're concerned, no. There's nothing in our lawsuit that would prevent them from going and building that store right now.
So they would build it at their own risk of an adverse interpretation of this restriction at some point in the future.
Correct, Your Honor. Okay. And really, it's what, as I got to earlier, it's and I believe you were kind of going that direction too. It's the economics of it. That we're trying to get to the bottom of what's applicable on this property before we spend a whole lot of money and a whole lot of effort in trying to undo it or construct it, on both sides, frankly. So, Your Honor, I see my time is up. I do believe I addressed your standing questions. I do believe I addressed the advisory. If there's any other questions, I'm happy to answer them. Otherwise, I'll see you anytime back.
Judges?
Thank you.
Okay. Counsel, this case is submitted and y'all are excused. And I won't say my other judges failed me in the other two cases, but I'm going to remind y'all to do your letter briefs on cases that you cited that were not included in your briefing or any other issues. Do it quickly if you would. Back in the old days when we had local rules, you had to do it by Friday. We don't have the local rules anymore, but the longer you wait, the greater the risk that we will proceed without the information that you want to provide us that would be helpful. So with that said, this case is submitted. Y'all are excused, and we will take his.
Mr. Doss, Mr. Rittinger, thank you very much for your excellent preparation and presentations.
Thank you, Judge.
Thank you, Justice.
Thank you for y'all's time.
And sorry, I left Matt Doss's name badge up during the rebuttal. Maybe they'll remember who you are, Jay.
That's right. That's good advertising.
That's
our high-tech system here.
Yeah, I appreciate the free advertising. I'll take anything I can get.